On the 2nd of August, some AI systems will have to tell you that they are AI. Hi, I'm Anna. This is Please Remain Human, where we look at AI and the implications for all of us. Here's what you may notice, what the rules cover, and what they mean for us. On the 2nd of August 2026, parts of the European Union's AI industry will be legally required to identify themselves. A customer service chatbot may have to tell you it is AI before the conversation begins. A deepfake may need a clear label when you first see or hear it. And where emotion recognition or biometric categorization systems are legally permitted, people exposed to them must be told. But do not expect a giant made by AI stamp on everything. The most important new mark may be invisible, and current technology may not always keep that mark intact. So, what will change on your screen? What will remain hidden? And who is accountable when the disclosure is missing? First, a correction to the headlines. The European Union AI Act entered into force in August 2024 and has been introduced in phases. Article 50's transparency obligations begin on the 2nd of August 2026. On the same date, the Commission's enforcement powers over providers of general purpose AI models enter into application. But other major parts of the Act do not begin on the same day. Rules for high risk systems apply from December 2027, while regulated products move to August 2028. So the entire AI Act does not arrive on one day. The part most people may notice is narrower. AI will increasingly have to reveal where it is present. The first change could appear before you type a word. Providers of AI systems designed for direct interaction with people must ensure users are told they are interacting with AI. The notice must appear from the start of the first interaction and be clear, distinguishable, and accessible. That could mean you are chatting with an AI assistant. There is an exception where the use of AI is already obvious, but the more closely a system imitates a human, the harder it becomes to argue its identity was obvious. The second change is more complicated. Providers of generative AI systems must design them so that synthetic audio, images, video, and text can be marked in a machine readable format and detected as AI generated or manipulated. This does not necessarily mean a visible logo. The mark could be embedded metadata, provenance information, an imperceptible watermark, or another technical signal that compatible software can detect. And that is where the first real problem begins. A machine readable mark is not proof. Technical marks can be altered or removed. Detection systems can make errors. Editing, compression, cropping, or deliberate manipulation can weaken the signal. Text is especially difficult because rewriting can disrupt many detection methods. The law recognizes those limits. It requires solutions to be effective, interoperable, robust, and reliable as far as technically feasible. So, transparency technology should be treated as evidence, not certainty. A label does not mean the content is false, and the absence of a detectable mark does not prove a human created it. The disclosure you are most likely to notice falls on the organization using the AI, not only the company that built it. Professional deployers of generative AI systems must clearly disclose deepfake content. A deepfake is AI generated or manipulated image, audio, or video that resembles an existing or plausibly existing person, object, place, organization, or event, and could falsely appear authentic or truthful. The disclosure must be visible or audible by the time a person is first exposed to the content. Hidden metadata is not enough. Not every AI image is automatically a deep fake. Clearly, fantastical material may not meet the definition. Artistic, fictional, and satirical works can also use a less intrusive disclosure. But there is a limitation. Article 50's deployer duties generally concern professional use. A private individual using AI entirely for personal, non professional activity may not be caught by this particular duty. So, a publisher, advertiser, or professional creator may have to label a deep fake, while a private person posting synthetic content may not. The next notice is not about content, it is about you being analyzed. Where emotion recognition or biometric categorization systems are legally permitted, the organization deploying them must inform the people exposed. But transparency is not permission. Emotion recognition in workplaces and educational institutions is already prohibited, apart from limited medical or safety uses. A notice beside a prohibited system does not make it legal. The least discussed transparency rule may have the widest reach. Professional deployers must clearly label AI generated or manipulated text published to inform the public about matters of public interest. That includes politics, public administration, justice, public health, security, environmental protection, finance, science, and major cultural developments. But there is an exemption where the publication has undergone genuine human review or editorial control, and a person or organization accepts responsibility for what is published. And the word genuine matters. Running a grammar check is not substantive review. Correcting spelling is not editorial control. A ceremonial approval button is not meaningful oversight. Editorial control means having the authority to approve, alter, or reject the substance, including fact checking and assessing sources. This is where human in the loop acquires an operational meaning. The human cannot merely be present. The human needs competence, authority, and responsibility. So, who is accountable in this system? Article 50 divides responsibility between two actors. The provider develops the AI system or has it developed and places it on the market under its own name. The deployer uses the system professionally under its authority. The provider is principally responsible for direct interaction disclosures and machine readable marking. The professional deployer is principally responsible for notices about emotion or biometric systems and for visibly labeling deepfakes and relevant public interest text. Employees working under an organization's instructions are not normally separate deployers. Responsibility remains with the organization controlling the system. A company should not blame the junior employee who pressed generate if the company selected the tool, established the workflow, published the result, and failed to create a review process. Enforcement will mainly sit with national market surveillance authorities. Penalties for Article 50 violations can reach €15 million or 3% of worldwide annual turnover, with proportionality for smaller organizations. Because much enforcement is national, implementation may not look identical across every member state from day one. From the 2nd of August, look for 5 changes. A notice when you begin interacting with certain AI systems. Machine readable marks embedded in synthetic content, although you may never see them. Visible disclosures on professional deepfake content. Notices when permitted, emotion recognition or biometric categorization systems are operating, and labels on AI generated public interest text that has not received substantive human editorial review. But transparency is not verification. A label tells you AI was involved. It does not tell you whether the content is true. And the absence of a label does not guarantee that a human created it. The more useful questions are: who provided the system? Who deployed it? Who reviewed the output? And who has the authority to correct, withdraw, or stop it? Because AI generated is useful information, but no identifiable human is responsible is the real operational risk. That is what Please Remain Human tracks. Not simply whether AI was used, but whether a human organization remains answerable for the result.